Schmitz, intern at Lawfare, with an episode from the Lawfare archive for January 21st, 2023. This past Tuesday, the Supreme Court heard oral arguments in Halkbank v. United States, a case which challenges prior interpretations of the Foreign Sovereign Immunities Act to protect state-owned entities. For today's archive episode, I chose to revisit a conversation from December 11th, 2020, in which Scott Anderson sat down with Professors Chimène Keitner and Ingrid Wuerth to discuss the Supreme Court's earlier rulings on foreign sovereign immunity and possible exceptions which have been raised by federal legislators. This snapshot, captured over 2 years ago, complements Wednesday's episode of the Lawfare podcast, wherein Anderson, again joined by Keitner and Wuerth, discussed interpretations of the Foreign Sovereign Immunities Act under Halkbank v. United States and the possible outcomes of the case now pending before the court.
I'm Scott R. Anderson, and this is the Lawfare podcast for December 11th, 2020. This week, the Supreme Court returned once again to the complex and sometimes controversial Foreign Sovereign Immunities Act, or FSIA, that protects foreign sovereigns from litigation before U.S. courts. At the same time, Congress is once again debating new exceptions to the protections provided by the FSIA on issues ranging from cybercrime to the coronavirus pandemic, an effort that may risk violating international law and exposing the United States to similar lawsuits overseas. To discuss these developments and where they may be headed, I sat down with two leading scholars on sovereign immunity issues: Chimène Keitner, a professor at the UC Hastings School of Law and a former counselor on international law at the U.S. State Department, and Ingrid Wuerth, a professor at Vanderbilt University Law School and one of the reporters for the American Law Institute's fourth restatement on U.S. foreign relations law. It's the Lawfare podcast for December 11th, the past, present, and future of sovereign immunity. So a few days ago, the U.S. Supreme Court heard argument in not one, but two cases relating to something that has become something of a perennial issue for those who follow the legal side of foreign relations and national security, particularly in the last 10 years or so, but going back further than that as well. And that's this question of sovereign immunity and the law that kind of implements a lot of sovereign immunity law in the United States, the Foreign Sovereign Immunities Act. Ingrid, can I turn to you? Tell us a little bit about these cases and what they say about the current state of the debate around sovereign immunity FSIA issues here in the United States.
Yeah, thank you so much, Scott, and thank you for the opportunity to be here. The Foreign Sovereign Immunities Act is a comprehensive statute that governs lawsuits against foreign nations. So these particular cases involve defendants like Germany, Hungary, the Ministry of Culture in a German state, the Hungarian National Railroad. If you want to sue these kinds of defendants in the United States, you must comply with the Foreign Sovereign Immunities Act, and it makes foreign states and their agencies and instrumentalities presumptively immune from suit. Now, both of these cases involve the expropriation exception to immunity. In order to invoke that exception, the case needs to involve rights in property taken in violation of international law. One of the issues involved in both of the cases is if the expropriation or another exception applies, can courts decline to hear the case based on the doctrine of international comity? So basically, the question the justices wrestled with was, does the doctrine of international comity survive the Foreign Sovereign Immunities Act? That question gets us into interesting questions about whether the executive branch or courts should resolve cases or make decisions with important foreign policy implications. The second issue arises in particular in the Philip case, which involves some wonderful medieval religious art that you can see in Berlin. It was owned by a consortium of Jewish art dealers, and it was sold under duress to the Prussian government in 1935. The question is whether the expropriation exception applies when the country is expropriating the property of its own citizens. The answer to that question is usually no, but because this particular case is linked to a genocidal taking, the plaintiffs argue there's a violation of international law. even if the taking is against one of their own citizens. That case, too, involves how much we should defer to the executive branch, which wants us to read the statute in one way. The plaintiffs want us to read it in another. And both of the cases, to my mind, raise this interesting question: to what extent should the United States be the right forum for resolving Nazi-era claims, expropriation claims against Hungary and Germany, respectively?
That kind of overview that Ingrid just gave us of these cases really, in my mind, illustrates the way the FSIA sits at the intersection, or in a way, kind of two different intersections that it tries to mediate. One is between domestic law and international law, sovereign immunity as a concept in international law, and for which the United States has obligations to respect in certain regards, but then the FSIA implements that and takes a somewhat idiosyncratic U.S. view of it in some ways. And then the other intersection is between law and policy, the need to reach legal outcomes, but in an area that often has major foreign policy ramifications where the executive branch has strong views among other actors. And obviously that makes this law somewhat not unique, but exceptional in certain regards of striking this difficult balancing act. Chimène, let me turn to you for just kind of a little bit of a background or explainer. How is it that the Foreign Sovereign Immunities Act, the FSIA, as to refer to it by its common acronym, ended up filling this role at the intersection of these difficult questions? And how does it kind of operate in practice today?
Well, hi, Scott, and I'm also very glad to be here with both of you. So the FSIA, as Ingrid mentioned, was enacted in 1976 to provide a comprehensive, judicially applicable answer to the question of whether certain categories of defendants were amenable to suit in U.S. courts. And although the FSIA doesn't say this explicitly, I think the best understanding is that it really was focused on civil jurisdiction, civil suits. So before 1976, the law of foreign sovereign immunity had evolved both as a matter of international law and, of course, as implemented in U.S. courts. The earliest case often cited with reference to foreign sovereign immunity is the Schooner Exchange case, in which Chief Justice John Marshall in 1812 said that a nation has exclusive territorial sovereignty, but that other foreign sovereigns who enter the nation's territory do so under an implicit license, essentially, that they won't be subject to suit in domestic courts while they're here. And so that foundational idea is codified in the FSIA. But of course, it took, well more than a century to codify it. The interim period, which I've actually discussed in an article titled Between Law and Diplomacy, so very much reflecting that point, involved a lot of cases against foreign ships that came into U.S. ports. And courts had to figure out, is this a ship that is a purely private ship on a purely private mission, in which case there was obviously jurisdiction? Is it a public ship of war of a friendly foreign sovereign, as was the Schooner Exchange, in which case it is beyond U.S. jurisdiction, even though it's sitting there in a U.S. port? Or is it some combination of the two? Is it a merchant vessel owned by a foreign state? And in that case, how do we split the difference? On the one hand, we want to make sure that claimants have access to courts to obtain judicially enforceable remedies. On the other hand, there is this idea that John Marshall emphasized of both sovereign equality among nation states, and then even more concretely, the need for states to conduct diplomacy and to be able to interact with each other without this threat of suit. And so over time, courts grappled with this issue. The State Department certainly grappled with this issue. And in 1952, the department actually came out with the so-called Tate letter, signed by then acting legal advisor Jack Tate, saying, here's what we're going to do. We've been doing this for a while, but just so everyone's on the same page, we see that international law is starting to differentiate between the commercial activities engaged in by foreign states and their public or sovereign activities. And it's going to be our policy to allow jurisdiction, to exercise jurisdiction with respect to the commercial activities, even of foreign states and foreign sovereigns, but not with respect to their public activities. The tricky thing was, at that point, the State Department was quite active in making what it called suggestions to court of immunity. And so foreign states, quite understandably, would pester the State Department for a suggestion of immunity. And when that situation became untenable, and when the results of that petitioning process became unpredictable as they were, Congress, at the request of the State Department and the Department of Justice, stepped in and came up with this act that we're talking about that endeavored to clarify all of these issues, although, as Monday's cases show, certainly left a number of issues unresolved as well.
Scott, if I might jump in there, I just wanted to mention an issue that arose at oral argument that's related to what Chimène just said. If there is a doctrine of international comity that survives the Foreign Sovereign Immunities Act, one way we might give effect to that is by having the courts listen to the executive branch about when a case should be dismissed because of foreign policy concerns. The problem with that, of course, is given the history that Chimène just described, that seems to get us right back into a situation in which we are deferring to case-by-case decisions by the executive branch. It doesn't have to be exactly the same regime, but there's this concern in FSIA cases about giving too much power to the executive branch because it takes us back to that pre-FSIA practice that did not work out well.
Now, that's an excellent point. And the other little footnote I'll just add is something I came across yesterday, which is the United States, the Solicitor General's brief in a pre-FSIA case called Alfred Dunhill. It actually made the point with respect to another doctrine, the so-called active state doctrine, that doctrine shouldn't be overused to essentially bring in immunity by the back door. And so the FSIA, although it does create, as Ingrid indicated, this presumption of immunity for certain categories of defendants, also was very much designed to make it easier to sue those defendants when they engaged in commercial activities being the number one exception. And then there's some others we can get into later on. It provides personal and subject matter jurisdiction if an exception to immunity encompasses the claim, and it provides very explicit instructions on service of process and so forth. So it was, on the one hand, designed to codify immunity, but on the other hand, also to make it much more straightforward for claimants in U.S. courts to be able to assert jurisdiction when appropriate.
That's a great lead into my next question, or the next issue I want to put to you. And that's really the FSIA, as you described, really put Congress in the driver's seat on these issues in a lot of ways, set out a statutory framework that superseded certain aspects of prior practice and maybe superseded more as the debate over international comity and other issues kind of entails this question of how much is Congress replacing of the old regime. And we've seen Congress wrestle with this responsibility. You're describing this balance between executive branch rules versus more defined statutory rules, also involving the role of private plaintiffs and the ability for them to engage in litigation that affects foreign entities or doesn't. And one area we've really seen this most commonly in the last 20 or 30 years that's proven kind of instructive in a way, or at least certainly notable as a trend, is around questions of terrorism, international terrorism. Ingrid, can you describe that a little bit for us? How has Congress approached this question of accountability for terrorism, and how is it related to the sovereign immunity context here?
The terrorism exceptions really illustrate how active Congress is in the Foreign Sovereign Immunities Act space. Congress has repeatedly amended the statute with terrorism-related issues. It also, I think, illustrates that Congress is obviously subject to very strong political pressures, particularly when it comes to terrorism, for better or for worse. But the first amendments specifically dealing with terrorism were in 1996, and they created an exception for state sponsors of terrorism. And so if the executive branch listed a particular country as a state sponsor of terrorism, then terrorism-related suits against that country country could go forward. The state sponsors of terrorism list was always very short, but this explains a large number of judgments, in particular against Iran, which was designated as a state sponsor of terrorism. But these initial amendments in 1996, they didn't create a cause of action, and they also didn't really provide any special mechanisms for enforcement. And Congress has acted. At first, it created a cause of action for terrorism-related cases, and it has enacted a variety of legislative measures geared toward execution of judgments against countries, in particular Iran. And Congress tends to move quite slowly here, makes incremental changes, but there has been a drumbeat toward opening up these cases, opening up the assets, in particular of Iran, for these judgments. And then Congress made, I think, a pretty big move in 2016 with JASTA, a statute that creates a cause of action against foreign states for injury occurring in the United States caused by an act of international terrorism. What's different about JASTA is it doesn't require the executive branch to list the defendant as a state sponsor of terrorism. So we've seen JASTA cases against Turkey, for example. We've also seen, most significantly, JASTA cases against Saudi Arabia. And indeed, Saudi Arabia was kind of the intended defendant when JASTA was passed. And it was passed with the events of 9/11 in mind, and after very significant lobbying by some interest groups. JASTA does not, however, create any special regime for execution of judgments, so it may be very hard for successful plaintiffs to collect. Plaintiffs who are successful, if they receive large awards, will no doubt return to Congress and ask for specific legislation with respect to execution of judgments.
That is a great overview, Ingrid. And I think just the two quick things I would add are, number one, of course, the FSIA in its statement of purpose indicates that its goal was to codify the restrictive theory of foreign sovereign immunity, under which a state's commercial activities are treated as the activities of any other private party would be for jurisdictional purposes. And although there's some debate about whether that restrictive theory really was customary international law in the 1970s, I think it's quite clear that it is today, and maybe the FSIA even played some role in helping to catalyze that development. These other exceptions, and terrorism notably, are not universally accepted as an appropriate basis for one state to exercise jurisdiction over the acts of another state in its own domestic courts. And so although Congress is certainly authorized under U.S. law and well within its power to enact the kinds of legislation that Ingrid just described, it does create some potential tensions, and it certainly diverges from the practice of other states to date. The goals I think that Congress has in mind, Ingrid mentioned, the really constituent demand for this kind of direct access to judicial remedies, although, as she also mentioned, the remedies themselves do prove elusive, especially with respect to states that don't have assets here in the United States that are subject to attachment and execution. So it's a claims resolution motivation. Claimants understandably feel that diplomatic avenues for recourse have been unsatisfactory, and that certainly going to the foreign country's own courts wouldn't result in a satisfactory compensatory regime. And so they look to U.S. courts and demand access because they feel that there are no really alternative avenues that are satisfactory for pursuing relief. And I also think Congress thinks of these exceptions to immunity, the ones that go beyond kind of those original 1976 exceptions, as maybe being sort of a tool in the United States' foreign policy toolkit akin to something like sanctions. In other words, a way to potentially deter future terrorist activity in addition to compensating for past activity. And whether or not these are well designed to actually achieve either of those goals is a separate question, but I think they're both worth keeping in mind.
Chimène, you've raised a couple of really terrific issues. If I could linger for just a second on the international law piece of it, as your introduction made clear, there is a backdrop of customary international law at play here. Customary international law limits the ability of one country to subject a foreign nation to the jurisdiction of its domestic courts. And the United States benefits tremendously from this. The United States cannot be sued in foreign domestic courts unless one of the exceptions to immunity applies, such as the commercial activity exception. In both the expropriation context and the terrorism context, the United States is, perhaps to put it gently, sort of pushing the envelope here and perhaps subjecting foreign states to jurisdiction in a way that violates customary international law. We could talk more about exactly how customary international law is violated and the arguments that perhaps it's not, but there's no question the United States is pushing the envelope here. And, one of the issues that came up at oral argument this week is, concerns with reciprocity. The United States, we like our terrorism exception. On the other hand, we enjoy immunity in other courts. And once you start making exceptions, it can be hard to limit those.
That leads in well into my question for you, Chimène, next, because this terrorism model that we've kind of seen, an opening of avenues towards civil litigation for private plaintiffs over around terrorism claims against, foreign sovereigns and foreign sovereign agencies, instrumentalities, is a model we're seeing begin to be experimented with, or at least thought about extending to other realms. You and I have actually sat on this podcast before and talked a little bit about sovereign immunity related legislation relating to China and the coronavirus and proposals that were along those lines a few months ago that are still out there. And then more recently, you've done some writing about another set of proposals specifically relating to state-sponsored hacking and cybercrime. Walk us through this a little bit. How are people thinking about taking lessons from this terrorism model and moving into these other issue areas? And what special legal and policy challenges does that pose?
I do think that Congress, at least this Congress, has started thinking about amendments to the FSIA as, again, just another tool in its toolkit to pursue various goals, including both deterrence and claims resolution. And so I think, as Ingrid may elaborate in a few minutes, it really doesn't have in mind either this international law backdrop or, quite frankly, the reciprocity concerns that have been mentioned. I think there's a feeling, because the State Department in particular has raised the alarm with respect to prior amendments, such as the terrorism amendments, and at least in Congress's view, the sky has not fallen. It has become a little bit inured, I guess, to those kinds of pushbacks. And so we can talk on sort of a broader level about whether we should view amendments to the FSIA in this way. I'm certainly of the view that we should not, although I freely admit that maybe I've gone a little bit native after my time at the State Department, but I do think that other tools are just categorically different, and that the FSIA was designed to serve important purposes that additional pushing the envelope exceptions, to use Ingrid's characterization, do not serve their purposes, number one, and do create a lot of other knock-on effects that may not show up for a while, but that are certainly there, number two. But in the two specific issue areas that have come up recently, Scott, as you mentioned, there is a bill, technically on the Senate calendar, although I don't see the Senate returning to it during the lame duck session, called, I think the acronym at this point is the Stop COVID Act. And it's a Republican piece of legislation. The vote in committee was almost exactly along party lines to create an FSIA exception for essentially countries that recklessly fail to inform the world community about an evolving pandemic. And of course, there are, details, and this bill that came out of committee is somewhat more restricted than some of the proposals that had initially been floated, but the general idea is, and I think some have referred to it explicitly as a JASTA for COVID. And so again, kind of conflating different kinds of issues, different kinds of conduct, on the one hand, acts of international terrorism on U.S. soil. On the other hand, the evolution of a virus that, although, the more information that comes out, the clearer it appears, at least based on public reporting, that, China is not only where the virus first arose, but also that both local and ultimately national authorities did conceal important information. But whether or not that is an appropriate subject for investigation, let alone resolution in U.S. courts, is an entirely separate question. And I think Congress has been conflating the two and suggesting that a U.S. court is an appropriate forum for figuring out China's role in the global pandemic. I think certainly puts much too great a burden on U.S. judges, even in the JASTA cases now, some of the ones that are going on in New York District Court. They're tremendously difficult evidentiary issues, just, to pick one of the many problems, including evidentiary issues raised by the United States' own interest in preserving the confidentiality of its sources and methods in our own intelligence gathering. So it really does get very complicated when we bring courts into the mix in these kinds of non-commercial cases, at least when foreign states are where foreign states are concerned. The HACT Act, HACT, is a piece of legislation that was put forward in the House. There had been some talk of including it in the most recent NDAA, but I understand it was not included. And I'm very glad that that is the case, because it would, as you alluded to in your question, essentially amend the FSIA to allow suits against foreign states for not only kind of malicious spyware type attacks, but really any kind of unauthorized intrusion into U.S. networks. And again, not only would that really open the floodgates to litigation, create tremendous problems of attribution, of proof, of figuring out, can you imagine, subpoenaing, the U.S. Intelligence community members to talk about how they made a particular attribution decision for a particular cyber attack. I mean, really just kind of nightmare scenarios, but also, as the United States has made very clear in the public record, we also push the envelope, to borrow a phrase, when it comes to our overseas cyber activities. And what was most surprising to me about the HACT Act, and the reason that our colleague Allison Peters and I wrote in the Lawfare blog about that act, is how many members of Congress seem to kind of jump on the HACT Act bandwagon without apparently thinking through just how expansively it's phrased.
So these very broad new proposals about these new kind of scopes of potential litigation and exposure for foreign states and their kind of subcomponents, it raises this question that you both have referenced in passing about reciprocity and the idea that the sovereign immunity principles that exist in international law are supposed to be reflected to some extent in domestic law, and departures from them can cause violations of customary international law and then consequences flowing from that. Ingrid, can you elaborate on that a little bit from us? Like, what is the concern about the United States drifting from the more accepted parameters of sovereign immunity under customary international law with legislative proposals like some of these and like some other developments that have arisen in the FSIA context?
Yeah, it's a great question to some extent. Chimène has already noted that concerns about reciprocity, at least in a very specific sense, have perhaps been overstated in the past. That is, if you think about reciprocity in a very narrow sense, the United States is probably unlikely to be subjected to lawsuits involving anything comparable to Nazi-era art expropriation, because we haven't engaged in that specific kind of conduct. So if you think of reciprocity in kind of those terms, perhaps you'd be most worried about it in the cyber context, as Chimène has already said. But, I think the question more generally is, does the United States feel that the, system of foreign sovereign immunity serves it well? And what are the general costs over decades of undermining it through legislation when it suits our domestic interests? I can put my cards on the table. I don't think that domestic courts are a very good way of resolving a whole host of international wrongs. And I don't think it's in the U.S. interest or actually in kind of the global interests to see a wider opening of many aspects of the Foreign Sovereign Immunities Act. Now, of course, the Act and the customary international law doctrine, has to evolve over time. And to take the cyber context example and actually the terrorism example as well, there is a fairly well-established exception to foreign sovereign immunity when it comes to what we call forum torts, that is tortious conduct in the forum. And this used to mean, a car accident. You could sue based on that if the foreign sovereign failed to take due care on the territory of the other state. Now, courts have really struggled with how to deal with the forum tort exception when it comes to cyber conduct. And that obviously gets us into where the conduct takes place and where the harm occurs, which is, are difficult issues in the cyber context. So, I think on the one hand, the immunity regime will need to evolve to reflect different technologies and different threats. But I think in the main, it is a very strong and very important set of constraints that operate on all countries to the benefit of the United States.
It's interesting to be having this conversation, Scott and Ingrid, at a moment when the United States, at least the president-elect, has committed to re-engage in multilateralism after 4 years of sort of ad hoc and largely unilateral foreign policy. And although foreign policy and international law are two different things, they are obviously interconnected. And so I think we've seen both domestically and internationally in the last 4 years real pressure on law and also on the sort of supporting norms that buttress and fill out kind of the codes of conduct that we have, whether it's domestically in governance or internationally with respect to the use of force or things like sovereign immunity. And when Ingrid talks about customary international law, just to make sure everyone's on the same page, this is essentially uncodified international law, but that is still absolutely binding. There is a treaty out there on foreign sovereign immunity. It has not entered into force yet, meaning we're still short of the number of ratifications for the treaty to become binding on parties that have ratified it, and the United States has not signed, let alone ratified it. So we are dealing with uncodified law at the international level, at least with respect to foreign states. We certainly do have very robust treaties dealing with things like diplomatic and consular immunity, which are separate. So when we talk about law, I think in general, and international law in particular, there are some who approach it more as kind of a series of inconvenient constraints, and others, notably, I would say many in the military, who recognize its extremely important value in structuring our relationships. And so these kind of longer term effects that Ingrid mentioned, I think, do feel understandably quite abstract to decision makers, especially who are trying to be responsive to the immediate needs and demands of their constituents, who, again, don't necessarily internalize just how difficult it will actually be to get payment on any judgment that they might ultimately receive from a U.S. court. But I also think there are broader conversations maybe to be had in terms of educating decision makers about the importance of international law. The United States' central role in making many of these rules, and the way in which, in the absence of both U.S. leadership and U.S. participation in some of these regimes, there will not just be a vacuum, right? Other countries are going to step in. And so, not to get us too far away from our core topic of sovereign immunity, but I think it is connected to this idea that we benefit from living in a rules-based international order, and chipping away at fundamental elements of that order, in this case, sometimes for politically expedient reasons, I think is short-sighted and something that we should be concerned about.
Let me push back with you on one aspect of that, Chimène, just at least to play devil's advocate for a moment here. And that is that while there certainly are the benefits provided by these rules-based systems, they often seem quite remote. And at least in regards to these sorts of proposals we've been discussing, the terrorism proposal that have been implemented, COVID and the Hacked Act and hacking bills, they're all aimed at something that's a little more immediate and concrete in terms of a policy need, or at least a policy desire. And that is kind of a twofold drive. On the one hand, it is to hold foreign actors accountable for bad conduct. And on the other hand, it is to provide a means of providing compensation to American citizens, American nationals who have been damaged by those foreign states' conduct. And that's a pretty compelling narrative, I think, for a lot of people, at least on first impression. And certainly it seems for many members of Congress, it's something that they take seriously. So I guess my question for both of you, and I'll turn to you first on this, Ingrid, is how effective have these measures that have been implemented, meaning, I guess, primarily the terrorism context, been at achieving those sorts of dual goals of accountability? And to what extent are there alternatives that might not pose the same tensions with international obligations and other issues that we see coming into play here?
That's a terrific topic and theme. I want to just make one quick addendum to something that Chimène said about the Trump administration and customary international law and the Biden administration coming in. I guess I just want to highlight that a lot of the ways that foreign sovereign immunity has been limited by Congress over the past couple of decades happened before the Trump administration. You know, JASTA was enacted over President Obama's veto. The other terrorism exceptions are long before the Trump administration. So I guess I don't specifically disagree with a lot of what she said, but I think we really do need to see these developments in a broader trajectory. And I don't think they are caused by, and in some ways, I don't even think they've been accelerated that much by the Trump administration. But putting that aside, so what should we do? We need to hold foreign actors accountable. Foreign governments do lots of bad things that harms U.S. interests, that harms U.S. citizens. What do we do about that other than amending the Foreign Sovereign Immunities Act? You know, it didn't used to be that we thought of domestic litigation in U.S. courts as the primary way of redressing harm to our citizens caused by foreign governments. We used to negotiate a lot of what are called claim settlement agreements, and these date back to the 1790s and earlier, in which basically the State Department goes out and says, hey, foreign government, you have, technically you violated your obligations to the United States in ways that have harmed our citizens. Why don't you pay us some money and we will compensate our citizens? Part of the doctrine is called espousal. And, you know, this is great examples with respect to Mexican returning to expropriation, right? Where Mexico expropriated a large amount of U.S. property in the 1920s and 30s. And we get these claim settlement agreements negotiated by Cordell Hull, and a lot of money winds up in the U.S. Treasury. And then the United States winds up then distributing that to the people who were harmed. So there are, and historically, that's how we deal with these problems, not through litigation. And I think it would be helpful for folks to keep that in mind. Now, there, of course, is a relationship, especially today, between the threat of domestic litigation and the willingness of a foreign sovereign to come to the table. To return to the Nazi examples, there are a variety of executive agreements concluded with Austria, Germany, and Switzerland in the 1980s and 1990s that were primarily brought about by the fear of litigation in U.S. courts. So there's no question that opening up, reducing some immunity might bring foreign sovereigns to the table in terms of negotiations. And in fact, JASTA explicitly contemplates that possibility. And I think Chimène probably has more to add here, but just to return to you asked how effective are these measures. I don't think there's a lot of free money sitting out there. And, some of these judgments wind up being satisfied by assets that have been frozen by the U.S. government that might be used for other purposes. I think if we start seizing Chinese assets in the United States, that will have a huge impact on trade and foreign direct investment. So I don't see a big pot of free money out there, Scott, but I'll let Chimène speak to that too.
Wow, there's so much to talk about and too little time. But it's the accountability piece, I think, Scott, is extremely important. And so many people, of course, feel vindicated just by having a judgment from a court, even if they're ultimately unable to execute that judgment and obtain financial redress. So it's very important for us certainly not to play that down. It's a little unsatisfying, I think, in international law, what the International Court of Justice has in fact made clear, that immunity really is procedural, not substantive. It does not in any way absolve a foreign state from legal, let alone sort of ethical responsibility for its wrongful conduct. It, quote unquote, merely says that another country's domestic courts are not the appropriate forum to resolve disputes. And so, the ICJ, the International Court, has kind of reconciled this accountability imperative with the international law of immunity by saying, well, there's still responsibility. I do think that's unsatisfying because the claimant then says, okay, but where's the concrete manifestation of that responsibility? Where's my judgment? Where's my official pronouncement that this conduct violated my rights? So there is an indisputable tension there. A couple of things could be done, though, precisely because, as Ingrid mentions, there aren't unlimited funds out there. I mean, some of these suits against China that have been filed are literally for hundreds of trillions of dollars. And, if U.S. claimants have a basis for suing China, then I suppose not only do claimants worldwide have a basis for suing China, but other claimants would also have a basis then for suing the United States for our, again, based on the public record, apparent, at a minimum, interference with the Centers for Disease Control's reporting and aggregation of various statistics, our failure to implement measures in terms of outbound transmission of the virus from the United States. So it does get very thorny. But I think one thing we could do, perhaps, is think about ways to align executive branch incentives in claim settlement more closely with the incentives that Congress people have to be responsive to their constituents. Because I do think that some of these terrorism exceptions, which Ingrid, of course, very accurately pointed out, come from a long time ago and have had bipartisan support in Congress, although pushed back by the executive branch. I think some of them do stem from a deep frustration with the executive branch and with the perceived or even actual inadequacy of its claim settlement efforts, the fact that it's constantly, of course, juggling multiple priorities in foreign policy. And so the individual needs of claimants don't necessarily rise to the top of the heap, or if they do, are deemed to conflict with other imperatives that are equally, if not more, pressing. And so I think that is a real conundrum. I will say, even though I didn't intend to suggest, and I'm glad Ingrid set us straight, that there's been a causal relationship between the unilateralism of the Trump administration and the FSIA exceptions specifically, as opposed to sort of a more general renunciation of various multilateral treaties and so forth. I do think the COVID exceptions are different, right? As I mentioned, they really have not been supported by and large by Democrats. And I think in addition to all of the reasons we've discussed, there's another important reason that Democrats have not gotten on this bandwagon. And that's because they recognize, in my personal opinion, appropriately, that this really is more of a political stunt than it is a genuine effort to seek compensation. And I'll explain that a little bit, because that's something I've resisted saying in public, especially since, earlier in the summer, I testified before Congress on this issue. And so I definitely didn't want to venture any characterizations there. But here I think it's appropriate to do so, especially seeing how this has evolved and the conversation has evolved over the summer. So the degree to which the COVID pandemic has become politicized in the United States, I think, is abhorrent. And it's so demonstrably contributing to a prolonged and much more lethal pandemic than we would otherwise have experienced. And so, to my mind, I think it's quite clear that the legislators who put this proposal on the table months ago did so as part of an overarching narrative that is also reflected in the decision of the president to label this the China virus, a real blame China strategy that ironically is in tension with the president's statements early in the spring that China was doing a great job and being very collaborative, but consistency has not been a hallmark of this administration. So, this blame China narrative, I think, really is what's been driving these proposals. And so although it certainly shares features with the terrorism exceptions that were passed on a bipartisan basis, it's also very much bound up in this kind of messaging campaign. And so what we should really do to give people relief from COVID is take measures and consistent measures to promote public health here at home. And, to a certain extent, the horse has left the barn on that. And it's really a shame that economic shutdown seems to be the most kind of the go-to response when some other things like just wearing masks would be so much easier. But in any event, I think defensive measures are really in order. And that applies also in the cyber realm. On the one hand, we certainly want to try to find how to compensate victims of cybercrime. On the other hand, maybe devoting those resources to building more robust infrastructure, to educating people about how hacking happens and how to be on the lookout for it. Of course, those who have already been injured will take little comfort in defensive measures, but seeking compensation and accountability is very much an after the fact set of priorities. And I think maybe on some of these issues, we need to think long and hard about preventive measures as well.
So, these have been areas we've been discussing where Congress is exploring these new models and new ways to adjust the law around sovereign immunities. But there are also a number of other areas where we haven't seen Congress as involved, and where arguably some people, whether it's the courts or whether it's scholars like yourselves, have advocated for Congress to become actively more involved, at least to clarify some of the confusion that's still there regarding the outer parameters and full scope of the FSIA. The cases before the Supreme Court are one example of that to some degree. I don't know if anybody was clamoring for Congress to clarify the application of international comedy, but it's certainly there as an outstanding question Congress could have stepped in to address. But another one that you've written about a fair amount, Chimène, is this question of how the FSIA applies in the criminal context. Tell us a little bit about that and the questions that have arisen and how Congress might be able to play a productive role in clarifying the law around them.
Sure. And I've also got some writing available on this for folks who want to dive into the details. But the basic two unanswered questions, and I think Ingrid will address at least one of them as well. We now know, after a 2010 decision by the Supreme Court, that the immunities of individual foreign officials simply fall outside the scope of the FSIA. The FSIA doesn't address them one way or the other, although, as I mentioned, at least with respect to diplomats and consular officials, there's quite robust treaty law and also domestic statutory law, but there are plenty of officials who are neither diplomats nor consuls, and their immunities remain uncodified at the moment. There's also, I think, an increasing recognition that Congress did not speak explicitly to whether its intent in 1976 was to say the only jurisdiction that will exist over foreign states and their agencies and instrumentalities shall be civil jurisdiction, or whether it was simply thinking, as we mentioned, about the civil litigation context when it enacted the FSIA, hence some of its provisions, as I mentioned, that essentially create a long-arm statute over foreign states and their agencies and instrumentalities for conduct that falls within an enumerated exception. The FSIA itself is codified in Title 28 of the U.S. Code, which, for those of you who remember civil procedure, is really the section that talks about civil litigation and courts in that context. And so I've dug fairly deeply into this, and my interest in it, and this is something Ingrid has blogged about as well, arose about a year ago when, as listeners might remember, an entire floor of the DC Circuit Courthouse was shut down for arguments in what was referred to at the time as this mystery subpoena case. I think we've very recently learned that the subpoena was most likely directed towards an Egyptian state state-owned bank, that there was an investigation that was sort of a follow-on of the Mueller investigation looking into apparently suspicious $10 million transaction with the Trump campaign. And the bank in that case, even though, of course, it was not a defendant in a civil suit, as we've been discussing thus far, was a subpoena target. And so the grand jury issued a subpoena, and the bank made the argument, which had been made unsuccessfully a couple of times before by other state-owned or state-affiliated entities, made the argument that it was immune from the subpoena because the FSIA only confers jurisdiction over civil suits and, by its terms, essentially erases or deprives courts of jurisdiction over anything else. So again, I think that's not a well-founded argument. It did not win in the DC Circuit. The Supreme Court did not grant review. And so it remains to be seen what the Supreme Court eventually thinks about it. There are cases in both the Second and Ninth Circuits now that involve this issue, but it's something that I think was not on Congress's mind in the 70s, but perhaps should be going forward, given that this issue seems to be arising with somewhat more frequency.
And another issue we've seen in the headlines, really just in the last few weeks, is this question of how sovereign immunity extends and what circumstances it extends to different foreign officials and heads of state. Just in the last few weeks, we've seen civil suits launched against, perhaps most notably, Crown Prince Mohammed bin Salman of Saudi Arabia in relation to the Khashoggi killing and actions he took against other kind of expatriate dissidents from Saudi Arabia in U.S. court. And it seems almost certainly to implicate this question as to what extent either the Crown Prince or his conduct might qualify for sovereign immunity. And these questions of how foreign official immunity actually operates in the United States is a little different, in part because it's been seen as outside the scope of the FSIA. Ingrid, can you tell us a little bit about that? I know these are issues that you've looked at very closely and where it seems that Congress hasn't really stepped in, much like the criminal context, to provide much guidelines.
Yes, it is a bit ironic that Congress keeps stepping in on lots of immunity topics, but not the ones that many folks in the immunity community would like to see some congressional action. So, yeah, foreign official immunity brings together a set of unresolved constitutional issues and unresolved issues of international law. Basically, foreign official immunity, as Chimène said, is not covered by the Foreign Sovereign Immunities Act. And so when an individual official is sued, the immunity to which he or she is entitled is governed by federal common law. The source of the court's power to make federal common law under these circumstances is at least somewhat disputed. A second separation of powers question arises because the State Department has argued that it has the legal power to make immunity determinations that are binding on the courts. And I think that is unconstitutional. And I've written something called The Case Against the State Department that argues that the State Department lacks that constitutional power. And the other policy matter, which is super important on foreign official immunity, is to what extent should it track state immunity itself? To what extent should we make, Saudi Arabia immune from suit, but open up the officials that work for Saudi Arabia to suit? These are important policy considerations that I think it would be super helpful if Congress addressed. Another lingering question that is raised by some of the examples that Chimène gave and may have occurred to the litigators in the audience is, what about personal jurisdiction? Which of these potential suits against China about COVID, when would there be personal jurisdiction? Lower courts have held that foreign states have no due process rights because they are not persons. That's based on some unfortunate dicta in the Supreme Court. The historical record is absolutely entirely clear that foreign states would have been considered persons within the meaning of the Fifth Amendment due process clause and are entitled to the same kinds of protections that individual foreign defendants to which they would be entitled. So lots of work for Congress, Scott, and lots of work for the courts. Immunity is an area that gives and gives and gives and gives and gives.
Indeed. And I think that immunity community that you referenced, Ingrid, is perhaps going to grow as a result. Yeah, on foreign official immunity, I agree. I mean, they as the Samantar Court, that 2010 decision I referenced earlier, observed, official immunity and state immunity are not congruent. So, for example, under the restrictive theory, we make states answerable or suable in U.S. courts for their commercial activities, with certain nexus requirements and other things. But generally speaking, if a foreign official, signs a purchasing or procurement contract on behalf of a foreign state, that official is not going to be personally liable for breach of contract, nor would that official generally be subject to jurisdiction. And so in the commercial activity exception doesn't really translate into the foreign official or natural person context. That's just one example. On the other hand, there are really interesting questions about particularly foreign officials who come to the United States and even some who retire here. Should they be allowed to live free from U.S. jurisdiction alongside their former victims who are here as part of an expat community? And certainly the Torture Victim Protection Act, just to take one example, provides a civil cause of action for torture performed under color of foreign law. So you can imagine that, generally speaking, defendants in what we call TVPA actions will be foreign officials. And so unless they're diplomats or heads of state, there may be good arguments for not recognizing claims to immunity in those circumstances. However, because foreign officials don't come within the scope of the FSIA, that also means that there's no one-stop shopping for things, as Ingrid mentioned, like personal jurisdiction. So those limitations would kick in, of course, as might other applicable doctrines, whether it's, again, for civ pro buffs, failure to state a claim or other kinds of bases for dismissal of these suits beyond immunity. The only footnote I'll add is just a really interesting case before the Ninth Circuit right now involving a suit by WhatsApp against the Israeli private company NSO Group for alleged hacking. And the NSO Group is now alleging that it should be considered a foreign official of states in general, not any particular state, but it argues that because its customers are exclusively foreign states, it should benefit from this kind of Samantar category of foreign official immunity. And so we'll see where that goes. But lots of creative arguments there. And as Ingrid said, lots of issues for academics, policymakers, and litigants to explore.
I want to put this to both of you just for some last kind of final thoughts. We've kind of traced over the course of this conversation the evolution of the FSIA from 1976 to the present day, from the vision of a law that was intended to pull kind of certainly the executive branch and to some extent the United States out of more politicized debates around immunities issues and to put them in a more rule of law framework. And that succeeded to do that in some regards, while at the same time opening and implicating an array of other political questions, policy questions regarding how immunity impacts in certain issue areas that are of particular concern to Congress, at least, or the certain people in Congress, certainly. Tell us about the trajectory of the FSIA from here moving forward. What do the next 50 or so years of the FSIA's history look like in your view? Is it a valuable tool that Congress is going to step in to hopefully fill these lacuna, provide additional clarity, continue on the rule of law evolution that it really took a huge leap towards in terms of making sovereign immunity much more of a legal question? Or is there a movement back towards more political determination, more political approaches, at least in the separation of powers context, to questions of sovereign immunity? And Ingrid, I'll start with you.
Thank you, Scott. And I'll just take this opportunity to thank you again, and also to say what a pleasure it is to talk about immunity with Chimène Keitner. What a treat. I want to note that some of the pressure on the immunity regime comes from slightly different places, and that's evident from the two issue areas we've looked at most recently. Some of the pressure on the immunity regime comes from human rights litigation, and the expropriation cases that we started the hour talking about fit into that, right? These are people in Hungary and in Germany who were the victims of terrible actions by the German and Hungarian governments, Saudi Arabia obviously has harmed folks, including Khashoggi. And there's a question, to what extent should these human rights cases about bad things that happen around the world be resolved in U.S. courts? And a lot of pressure on the immunity regime, especially in the courts and especially in the context of foreign official immunity, comes from this desire for the United States to be a forum in which justice is finally meted out to bad actors. That's a little bit different, perhaps, than the pressure on the Foreign Sovereign Immunity regime that comes from harm to U.S. citizens. That's a pressure that we've obviously talked about with respect to cyber and COVID and the terrorism exceptions. And when we think about the future and how we're going to deal with immunity, it's interesting to think about the global position of the United States. It feels to me like the moment or the decades of exceptionalism have perhaps passed, and even the appetite to be an epicenter for human rights litigation may be waning a bit. With respect to harm to U.S. citizens, I'm not sure how that's going to play out, and I'm not exactly even sure what the right balance is between the executive branch, Congress, and the courts, but I am sure it will continue to be a moving target.
Well, likewise, just adding my thanks to the chorus, both to you, Scott, and to Ingrid Wuerth, who, again, is, yes, the ideal interlocutor on these issues. It is ironic, I think, that the Department of Justice and the State Department in the early 1970s came to Congress basically asking them to codify foreign sovereign immunity in order to depoliticize it and to make it more predictable for litigants. And then here we have now a conversation that is, if nothing else, shown all the ways in which the regime has become quite unpredictable and unstable, at least with respect to certain discrete issue areas, although, of course, quite successful in more run-of-the-mill litigation. So I really think we're at an inflection point. I think that the HACT Act and the Stop COVID Act are perhaps emblematic of a trend to looking at amendments to the FSIA as, just another tool in Congress's toolkit. And I think that would really be a mistake for all of the reasons that we've discussed. I think that they come from different places. Again, the HACT Act having at least had initially, before people thought twice about it, I think bipartisan support. And so maybe the product just a little bit more of knee-jerk piling on as opposed to serious reflection. The COVID bill, quite differently, that are really, as I mentioned, public relations goal, which is not entirely inappropriate for legislation. Of course, that is one way that Congress, attempts to be responsive to the needs of the American people. But in this case, I really think, it's been in lieu of the measures that Congress really should have been focused on. So if these two pieces of legislation do not move forward, if what we're left with at the end of the day is the terrorism exceptions, and if we then get some experience under, in particular, the newest exception, the JASTA exception, and see whether, it results in compensation from Saudi Arabia for the 9/11 attacks or not, then maybe we'll have some more data points in figuring out whether or not it's an experiment worth trying in other contexts. I think my assessment at the moment, quite clearly, is that it is not, that the attempt to create leverage by hiving off different kinds of activities, state activities from the core of sovereign immunity, it will not ultimately result in the hoped for settlements, and moreover will have dangerous knock-on effects. But, although it may be an unsatisfying note to end on, I think Ingrid is right. Time will tell. But I don't think that the outcome at this point is predetermined. I really do think it is in Congress's hands, because that's where DOJ and state put it, even though maybe they've lived to regret that. And I think that conversations like this one hopefully will help to bring to light some of the considerations that may not always be front of mind when discussing these issues.
Well, we are out of time, so we'll have to leave the discussion there. Ingrid Wuerth, Chimène Keitner, thank you for joining me today on the Lawfare podcast. The Lawfare podcast is produced in cooperation with the Brookings Institution. In addition, the discussion in this episode originated with a session of the Congressional Study Group on Foreign Relations and National Security, a project sponsored by the Carnegie Corporation of New York. please take a moment to rate and review the Lawfare podcast on iTunes, Spotify, or wherever you might be listening. This podcast was engineered by Zachary Frank of Goat Rodeo and edited by Jen Patcha Howell. Our music was performed by Sophia Yan. As always, thank you for listening.